So first of all, hello everyone, and thank you so much for inviting us to speak at this wonderful event today. And thank you so much, Shannon. That was really inspiring. I loved everything you said. So my name is Sabrina, and I lead the policy and public affairs work at Just Right Scotland, and I'm joined by my colleague Maisie Wilson, who's our legal caseworker. Um, for those who don't know us, Just Right Scotland is a law centre and we use the law to extend and defend people's rights. The organisation is staffed by human rights lawyers and human rights defenders, and we provide direct advice and representation to people where there are gaps. So we run a collaborative strategic model looking for specific cases that will make a change for people. And we always look that people can secure their human rights in Scotland. We also bring together third sector organisations to ensure that they inform the work that we do, and we have 4 legal centres of excellence. Today, we're here to talk about 2 separate issues that involve young people and youth work. The first one is migrant children in care with precarious migration status, and the second one is access to justice. So next slide. No, this one is fine. So the first one is migrant children in care with precarious migration status. And why is that an issue and why is that important? First of all, there are around 200,000 undocumented children all across the UK. And the numbers are rising pretty fast. You can see that on the slide, it says from 2017, and we can see that it continues to rise. Only 10% of them were able to apply to secure their immigration status. Now, many of those young people live in Scotland and many are in care. Over 100,000 people of them were born here in the UK. Now, their visas are dependent on their parents and it cannot be broken. If it gets broken, if it breaks, then their visa breaks, making them undocumented. So permission to live and work in the UK is called leave to remain, and it is subject to conditions. And there's a very stark difference between limited and indefinite leave to remain. Now, if a young person is about to turn 18 and they're in care and they have no leave to remain, it means that they cannot access work, they cannot access education, some benefits, they cannot get married, they cannot travel overseas. But the worst consequence is that they can be detained and removed to a country to which they have no connections whatsoever. And next slide, please, Maisie. As you can see from this very extensive list, if a young person has limited leave to remain, then they might not be able to access all of the things that you see there. And in general, it becomes very difficult to access education, to get a job, and overall life for a young person is very, very unsettled. And that's, of course, it's all part of the hostile environment of the UK government. So why is that important to know? For us at Just Right Scotland, since May 2017, we have worked with over 75 children who have been in care with precarious migration status across different local authorities. So it's not an issue that we see just in one locality in Scotland. On average, they spent 4 years in care before being referred to us. The average age of referral is around 15, but we have worked with very young kids as young as 8. Now, they were referred to us because something triggered an understanding that they were undocumented, whether they were trying to fill an application for college or whether they wanted to apply for a driving license or getting a passport because they were planning a trip abroad. Now, if the referral comes in too late, which is our experience, then it can be too late for us to sort it out. And as I said, that can lead to extremely serious consequences, including removal from the UK. That, of course, I want to stress that that doesn't happen because of the deliberate fault of social workers or local authorities, but there are a lot of different reasons as to why it happens. And next slide, please. So first of all, what's important to know is the nationality and immigration law is really complex. It also changes every 5 minutes. So it's hard for people in the sector to just keep up with all those changes. And people are also worried that by asking specific questions about nationality and migration, it can be seen as racial profiling. So sometimes the question gets avoided in the first place because there isn't a proper process in place. And also, social workers and people who work within local authorities don't want to engage with the Home Office hostile environment. And again, it becomes an issue later on. Now, also, this is not the most important argument for us to make, but it is still relevant to note that local authorities could save up quite a lot of money, and some research has been done on this, that they could save around £130,000 per child in some scenarios if the issue of nationality is solved earlier on in their care journey. This is a problem that exists because it is quite difficult for those trapped in this situation to access support, to find the right people, but also to have enough time or resources. And those young people, when they leave care without a plan in place, they're really at a higher risk of experiencing homelessness and destitution. However, there are two most important things that are key here. And next slide, please. So if a young person is brought into care, they are made undocumented because the dependency on their parents' visa is broken. And that's something that local authorities are not aware of. So they involuntarily make young people undocumented by bringing them into care. And the second very, very important point is that being born in the UK does not make people British citizens. We don't have birthright citizenship in the UK. So if there is a British birth certificate, that does not make the person a British national. So next slide. I have added these two slides because I think that the presentation might be shared after, and I wanted to give a couple of examples of people that have been referred to us from our casework. So it's not for me to go through those two slides, but it's just for people to have them once the presentations are shared. So Maisie, you can go on to the next one. There are a couple of things that need to happen now, and that's what we've been working on for the past year and a half. So first of all, we should try and identify those children with migration and nationality issues as soon as possible. However, the problem here is that we do not have data on that, and we do not have a centralized system that records this type of information and shares it across local authorities. So the second strand is on prevention. We also need a system change that has immigration and nationality at the top of the care plan to ensure it gets addressed at the beginning of the care journey rather than at the end, so they can be referred to specialist advisors like ourselves or others as soon as possible. So if they don't have a British passport or certificate of registration, the issue can be solved earlier on. And next slide, please. I've added other two slides here that explain how to work on early identification, and it can be done by anyone who's really involved in the lives of young people in care. So it starts with identifying nationality and immigration status early on, and it really needs to be clearly explained why that's being asked. So the issue of racial profiling gets pushed on the side. And when it becomes clear that the child does not have British nationality or leave to remain, then they are referred to external specialist advice as soon as possible. And next slide, please. I've just added here that, again, immigration law and nationality law changes very, very often. So it's easy for people to get lost in all those changes. Now, there are some positive examples from across the UK. So there is a charity called Greater Manchester Immigration Aid Unit, and they worked over the past years with Manchester City Council on a pledge to identify those young people with precarious migration status and get them to citizenship as soon as possible. And now in Manchester City, that is standard practice. And they've adopted the pledge, and the idea is for other local authorities all across the UK to adopt the same pledge. There is also another positive example that comes from Northern Ireland, where an audit was carried out to identify those children and young people in care who were undocumented and help them applying for British citizenship. This is not something that we always say, but they've also helped with cost of applying for citizenship, which are quite high. Next slide, please. So very quickly, what are we doing here in Scotland? We're working on this as Just Right Scotland, but we're doing it with a cross of partners, a lot of partners across the sector. We started working with COSLA right at the beginning of this project because we wanted to make sure that we're aware of this issue. We're working with different local authorities and social workers because we want to bring about this system change that I've talked about. We are also running a pilot scheme in a specific local authority in Scotland, and we have started doing some training across localities. So all this knowledge gets shared and gets, I guess, filtered down different teams. We are also bringing together young people, foster carers, social workers, and solicitors to design a system that works for everyone. Because of course, those people will have different experiences, different challenges, and different ideas on what can work for them. And so we're putting all of these experiences and knowledge together so that whatever we come up with, it's something that can work for everyone. I know this has been fast, but I hope this has been helpful. And please let me know if you have any follow-up questions. I'll pass over to Maisie for the second part of the presentation. And thank you so much.
Thanks, Sabrina. I'm going to talk about access to education, and it'll be quite brief. Perfect. Firstly, it's key to understand that the right to education is enshrined in international law, as I'm sure most of us here will know, and it's an instrument such as the European Convention of Human Rights, the Human Rights Act in the UK, and also the UNCRC. What this looks like in Scotland is that everyone has the right to access school and further and higher education, such as university and college, but that the right to education is not necessarily equal, as there's barriers, and that's often funding. As if somebody cannot access funding, they often cannot access education, specifically higher and further education. As if somebody's classed as an international student, that can see fees of tens of thousands of pounds each year. So residency requirements set by the Scottish Government had created barriers to many migrant young people from being accepted as a home student, and we would receive inquiries from individuals regarding this issue with each new academic year, and an obvious trend began emerging. This was also experienced by an individual called Ahmed Al-Hindi, who, although he'd received 6 higher qualifications and 2 advanced hires during high school, and was also offered unconditional offers from different universities to continuing studying, he struggled to be able to go because he was not considered a home student, even though he'd set all of his education in Scotland. In February 2022, he began a campaign called #OurGradesNotVisas, which you can see on the screen. In April 2022, Ahmed, along with Maryhill Integration Network and ourselves, released a survey to determine how many other young people were facing the same barriers. And it was Ahmed's campaign, along with the work of Maryhill Integration Network, that really got the ball rolling. So that's why I've included them, because they really put the idea on the table of it all. During this time, we received a referral from an MSP regarding one of their constituents. She was a 19-year-old Iraqi young person who'd moved to Scotland when they were 11 years old. They'd received an unconditional to study medicine and had already begun the course. When they were 17, they were denied access to student funding because they'd not lived in the UK for 7 years, and they were only 58 days short of this. But they'd been denied funding that year, and they were denied funding every year since. This was due to something called the long residency requirement, which is on the screen. So to access funding at the time, you had to be ordinarily resident in Scotland, which means that you're registered at address in Scotland and you pay council tax to an address in Scotland or something similar. You've lived in the UK for 3 years and you have indefinite leave to remain, or you have limited leave to remain. And if you're under 18, you'd have to have lived here for 7 years. And if you're over 18, you'd have to live here for half your life. So this slide just further kind of demonstrates that. And this long residency test meant that up until the age of 18, you'd have to live here for 7 years. But once you turn 18, on that day, you had to have been living in Scotland for half your life. So this is referred to as a cliff edge overnight long residency test, jumps from 7 years to 9 years. And if you're not eligible on day one of the first day of your course, you remain ineligible throughout, even if you then meet the residency requirements. So we brought this case and a similar case to court against Scottish ministers about how the rules were unfair, specifically the parts about 7-year and half-life requirements. As our client didn't think it was fair that she'd missed out by only 58 days. And it's an extremely extensive test to see if somebody's connection to Scotland was enough. And this was a key idea, as an individual needed to be able to demonstrate a connection to Scotland. But we believe that this is as much about looking forward to a potential life and contribution and connection to Scotland than that a prospective student and young person might have, instead of just looking back at their past, reflecting in length of residency, especially for a child, because they're not usually the ones that get to decide where they go to school. So the judge found that the criteria was a violation of the right to education, stating that the right to education has to be recognised as a fundamental right and is key to a functioning and democratic society. Eligibility for student funding was meant to help students who were most likely to call Scotland home and contribute to Scottish society after graduation. Yet our client, who'd wanted to study medicine in order to work as a doctor for the NHS in Scotland, had been denied this, as she'd been short only 58 days. Thus, the rule was detrimental to both our client and Scottish society and the contributions she would have made going forward. The judge deemed that the long residency rule excluded eligibility for student support for individuals such as our client who had a clear and continuing connection to Scotland. And as such, the judge ruled that the legislation was unlawful in light of both Article 14 and Article 2 of Protocol 1 of the European Convention of Human Rights. So Article 14 is the right not to be discriminated against, and Article 2 of Protocol 1 is the right to education. So following this, the Scottish Government published a consultation and we began a kind of information raising campaign. We hosted an online event to discuss the outcome and what it might look like, along with hashtag Our Grades Not Visas campaign and the Maryhill Integration Network. We also ran outreach sessions and continue to do so, both for service users and service runners, and updated fact sheets as we went to keep people informed about what their right to education was. We submitted our own consultation response, and we also ran an event for our lived experience panel at Just Right, who are called Just Right Citizens, so that they could submit their own response and their own thoughts on the matter. And then we have also continued campaigning, which has been led by hashtag Our Grades Not Visas and the Maryhill Integration Network. As a result, for some good news, there's been a change to the legislation in Scotland in a move to create a more equal access to education for young people. The long residency requirement's been abolished, so the 7-year and half-life requirements are gone, and it's been replaced that if people have limited leave to remain in the UK and they just need to be resident in Scotland for 3 years and a resident in the UK for 3 years and resident in Scotland on the first day of their course, or the first day of the academic term it's called, which is usually the 1st of August. And the policy was also extended to include home fee status and tuition fee support to unaccompanied asylum-seeking children and children of asylum seekers. And this change is in recognition of the impact that delay to an asylum claim can have on a young person and a child's learning journey. So this brings us to what still needs done. The Scottish Government noted that there was a call from those who responded to the consultation for asylum seekers who've been waiting for a decision for longer than 3 years that should have greater opportunities to access further and higher education, as people should not be punished due to the lengthy delays in the asylum decision process. And the Scottish Government said they're going to monitor these issues, so we're keeping an eye on this. But there's other issues that have arisen through this as well, and from people who have contacted us, such as there's a discrepancy between university guidelines and SAS policy. So the SAS policy's changed, and that's regarding funding. But universities can set their own criteria as to who's a home student and who's an international student, which can vary slightly, which affects people greatly because that's the difference between getting free university education or paying 10 grand a year for university. There's also the investigation into possibility of damages for those who have had to pay international fees incorrectly. The SAS set up a payment scheme for 2020 to 2022, I think, for people who've had to pay international fees, but there's obviously years worth of people that are in huge amounts of debt because of what they've had to pay. And finally, we continue to work with communities and grassroots organisations to make sure everyone knows that their rights are and what to do when those rights are not respected. This all wouldn't have happened necessarily without the work of Ahmed and the Maryhill Integration Network. So it's vital for us to continue to raise awareness of what people's rights are. And finally, what can you do? As individuals, we have a responsibility to continue to educate ourselves on important matters and to equip ourselves with the knowledge of what our rights are and also what the rights of others are. Education, as has been discussed today by many, is so fundamental for young people, and we ask you to continue to learn more, raise awareness of important issues, what rights are, and support campaigns such as the #OurGradesNotVisas campaign. And from Sabrina and I, thank you.